Hey everybody, John Skiba here for the Consumer Warrior YouTube channel. I am on my way back from a trial in a debt collection case. Thought I'd give you a kind of post-mortem, kind of how this whole thing played out. So first of all, it's kind of weird to be back in a courtroom. We don't, it used to be pre-COVID, I was in a courtroom every day, every working day of the week, whether it be bankruptcy court or whether it's in Justice Court, Superior Court. We're just in the courthouse all the time. And post-COVID, almost everything's gone virtual. Even trials are gone virtual. So this was an in-person trial, which like I said, it's been a while since I've had one in person. We do them via Zoom. I've even done them over the phone. But it was good to be back in a courtroom. So the trial went well. This is a case where they were claiming that there was a car loan that had been sold to a junk debt buyer, and the junk debt buyer was trying to collect on it. One of these cases where there was, I always say junk debt buyer cases, they're all bad, but some are worse than others as far as the evidence. This one lacked evidence, lacked written contract, lacked signed contracts, lacked an assignment that had any type of information identifying my client, identifying the vehicle, and they didn't have a witness from the plaintiff. They had a witness from the original creditor, which is kind of a twist on things a bit. But so I thought it went well. I think that the court had experienced or expressed some concern, obviously, particularly with the assignment and of them meeting their burden of proof. And so the judge did what a lot of judges do, at least here in Arizona. They took it under advisement, meaning that they're going to go back, look at all the exhibits, and then issue a ruling within a week. Truthfully, I think they know already how they're going to rule in like 99% of the cases. I think they like to just help everybody avoid that awkward situation where someone wins and someone loses and you're sitting right there with them. That's my opinion, but that's what it often feels that way, that it might be a little awkward if I say, hey, you didn't prove your case, or hey, now you owe a bunch of money, and so they'll issue a written ruling later. So we didn't get the verdict today. We will get that, like they said, within a week. But I wanted to give you a couple thoughts, or a couple tips if you're dealing with a debt collection case. The first thing is, I talk about this all the time, that the number one thing to do is to show up. 95% of people don't file an answer, they end up with a default judgment. If you're part of the 5% that show up, or if you come to trial, you start to see that a lot of these things are that they don't have the documents, they don't have the witnesses that can really establish anything. And that's kind of what I experienced today. Is if my clients wouldn't have responded to this, if they would have just ignored it, it would have been a default judgment, big judgment against them. And the court could still rule against them, but we'll see what happens. I feel pretty good about it because of how little documentation there actually is. I can also tell you when it comes to, let me give you some of my favorite questions on cross-examination, because if you're in a trial, an arbitration hearing, you're going to get a chance to cross-examine the creditors or the junk debt buyer's witness. One of the first questions I ask them, because they will have just gone through all these exhibits, testified about how the documents are accurate and how they are authentic and they are the best of the best. That these are everything, that they're totally unimpeachable. One of my first questions is I say, hey, your attorney just went over exhibits, 1 through 4 with you. Yep, they did. Prior to your testimony today, when did you first review those documents? And 9 times out of 10, they say something like this morning or last night. So it kind of takes a little bit of wind out of their sails as far as them saying, yeah, those are your documents. That they're totally correct and everything's accurate in there, and judge, you can rely on that in my testimony, because often they admit that they looked at them an hour before they walked into the courtroom and they're essentially just reading off of them just like everybody else is. So that's one question I always recommend, just because maybe it's me, maybe I like to give a little dig to the creditors, the junk debt buyers and their witnesses, but just getting them to admit, look, you didn't put a whole lot of time into this. You put maybe 15 minutes prior to your testimony today in court. So that's something that kind of a quick tip that I would give you if you're dealing with that. And then the other is just to be prepared and know that there's always things that happen in court that you can't control. Like today, particularly this happens in Arizona a lot, particularly in our justice court system, which deals with a lot of the debt collection cases under $10,000, is that some people will say, well, what judges are good or what judges are not good for our case? I don't ever put a whole lot into that. And the reason why is I showed up to court today and the justice of the peace that sits in that court was not there. It was a totally different judge. And so if you had prepared your arguments completely, to a particular viewpoint of a particular judge, then you're in a situation where now you're dealing with someone totally different. So that's why some of the principles I teach in Consumer Warrior University and in some of the tutorials are really just foundational principles or foundational ways to approach these cases, not based on a particular judge. If you happen to get a judge that's sympathetic to your arguments, all the better. If not, the arguments that you're still making are sound. So you just kind of got to be a little bit ready for anything, prepare well in advance. And my last bit of advice, I give this to all new attorneys: show up early. My trial today started at 1:30 and I got myself there at 1 o'clock. I've been doing this for 20 years and I still want to be there early. The reason is, if you show up late, one, if you show up late, you're probably gonna have a judgment entered against you. But two, if you show up late and or right before it starts, you're frazzled. You haven't had time to really kind of look at your documents, make sure you know your arguments, you're prepared to do an opening statement, all those little types of things that once you kind of put them all together, that's what makes a good case and shows the judge that you're prepared and that you're to be taken seriously. Even though you may not have an attorney, you're to be taken seriously because you put a lot of effort and it's well thought out. So hopefully that is somewhat helpful. Hopefully we get a good ruling on this one. Again, good to be back in the courthouse. I just think it's changed forever. I don't know if it's ever going to go back to like it was, and I guess it's way more efficient. It's cheaper overall for clients and taxpayers and everybody else, just because of you're not having to, at least in Phoenix, where everything's so spread out. Now I've got to drive 45 minutes back to the office. But it was good to be in a courtroom once again. It's a little different though. Things used to be kind of a bustling place, and now it's a kind of a ghost town, except for a few lawyers mulling around like me. So, all right. It's good to talk to y'all. Thanks for watching the channel. We'll talk to you soon.